pleasure to see you all today. I'm very happy to be here in Toledo. I had my first in-person event this morning at the law school in more than a year and a half, and it's really a treat to be able to come to the law school, come to your lawyer's chapter, and talk to you today. The topic today is ABA Model Rule 8.4G. Now, you may have never heard of it. Ohio hasn't adopted it. But this rule has been in the works for some time. And if this rule is adopted, it poses severe threats to attorneys, their free speech, and how they go about living their lives. This rule was first proposed by the American Bar Association in 2016. Now, the ABA proposes rules, but those proposed rules have no actual effect. It's up to state bars to adopt them. Let me actually read to you the text of the rule. Under the rule, it is misconduct for an attorney to, quote, engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, I'm out of fingers, or socioeconomic status. Well, 11. I don't have enough fingers to count them all, so I gotta go maybe take my socks off and go count my toes, right? So there are 11 bases. So again, let me reread the rule to you. If you engage in conduct that is harassment or discrimination on any of these bases, or if you reasonably know it's harassment on any of these bases, you've engaged in misconduct. Okay? We're not merely talking about discrimination, you fire an employee because of their race. It's harassment or discrimination. What is harassment? Okay. Harassment is a term that may be familiar to employment lawyers. Have you guys employment lawyers? Okay. There's something called sexual harassment, which is a fairly well-established body of law. If you have some sort of severe or pervasive workplace conduct that creates a sexual impropriety, it's harassment. But this is not sexual harassment. The term is far broader. Okay? Now, where does this rule apply? It applies in conduct related to the practice of law. Conduct related to the practice of law. What is this conduct? Okay, got my fingers again. Representing clients, interacting with witnesses, co-workers, court personnel, lawyers, and others while engaged in the practice of law. Okay? Operating or managing a law firm. And here comes the last one, number 8. Participating in bar association, business, or social activities. I got 10 fingers, right? The key one is the last one. Social activities in connection with the practice of law. All of you 5 members of the bar sitting here right now are engaging in the practice of law. Did you know that? I didn't. But you are all engaging in a social activity in connection with the practice of law. This is a CLE, right? Continuing education. The CLE tonight? Oh, damn. I thought it was CLE. Anyway, in theory at least, you are all engaging in a social activity related to a function connected to the practice of law. So if I were to say anything tonight that violated 8.4G, I would be within the scope of this rule. If any of you were to say something at your table while you're eating those delicious hot dogs, right, about 8.4G, you would be subject to the rule. This rule is designed to expand the scope of authority for the bar. Or stated differently, the bar can now intrude on greater aspects of your existence. Right? It's not merely if you're in a courtroom or representing a client or drafting documents or even engaging in a mediation or deposition. This rule is designed to govern social activities connected to the practice of law. Now, I don't know about you, but most people I know are lawyers. It just happens to be. And a lot of the social events I go to are with attorneys. Bar dinners, Federal Society dinners, hot dogs at the law firm, right? You are all now would be subject to this rule. Now, thankfully, Rule 8.4G is just that, a model, right? It doesn't have any force on its own. Instead, after the ABA proposed this rule, it would go to the states. And the state bars would decide whether they were going to adopt this rule. In 2017, I was one of the first critics of this rule. I wrote an article about it in a journal, and I urged state courts to pause and consider the First Amendment implications of this rule. Since 2017, I filed comments in almost 24 states urging the state Supreme Courts and whatever the licensing bodies, stop. Don't do this. This is a bad idea. A couple of the states have actually cited my work saying, okay, we're not going to do this, but the project moves forward. So let me give you the rundown. And this changes every few months, but I want to try to give you the most recent rundown. 6 states have formally rejected the rule. 6. So you got Arizona, Idaho, Montana, New Hampshire, South Carolina, and Tennessee. So at least you got one Sixth Circuit state in that list. In 3 states, the petitions were withdrawn after a comment period. In other words, they put it out for comment, they got a cluster of negative comments. They said, never mind, and they withdrew the petitions. Nevada, Louisiana, Alaska. There have been a few states where the comment period closed, but no decision was issued. And we're talking like 2 or 3 years have passed since the comment period closed. These courts are sitting on things. New Mexico, Utah, and the biggie, D.C. Now, I don't know about you, but there are a lot of lawyers who are barred in D.C. to do federal practice. If D.C. adopts, that would be huge, huge. Only one state has adopted 8.4G in its entirety, Vermont. And it did so very quietly. No one even knew it was happening. So you know the Bar Journal, right? This little magazine you get in the mail every few months. There was a little notice that was about this big that said, we are considering Rule 8.4G. Please submit comments. No one even noticed it. It was deliberate. Come on, guys, right? It was done in such a fashion that no one would even know it was there. And they adopted it without any public comment. In fact, they said, there's no public comment, because they put a little notice in the Bar Journal about this big, right? Okay. 3 states have adopted a more narrow version of 8.4G. New Hampshire, Maine, and Pennsylvania, the birthplace of the Bill of Rights. Pennsylvania is an odd one, because they adopted a rule, and a federal judge in Philadelphia said, this rule is unconstitutional. It's a violation of the First Amendment. So what did Pennsylvania do? They filed a notice of appeal. And then they withdrew their appeal. They said, okay, we're going to lose this case, right? So they said, let's go back to the drawing board. Do they have another public comment period? Of course not. That would have been too, actually normal. Instead, I'm not making this up, the Pennsylvania Supreme Court allows emergency rulemaking powers in the event of some sort of dire circumstance. They invoked the emergency exception to avoid a public comment period. And they passed a rule without any public comments. And I'll tell you, the rule they passed was even worse than the first version. They learned nothing from the judge's ruling, and they actually made the rule more vulnerable. It's currently before the district court in Philadelphia, the same judge. The briefing schedule is going on now. I think there'll be probably arguments in the fall. So I expect this Pennsylvania rule to be stopped again. Right? You might ask, why is the bar so eager to put this rule through without any public notice? Because when people scrutinize this rule, it falls apart very quickly. So they want to go like shadow, right? The shadow docket, right? They want to do shadow docket for the 8.4G. There's an elephant in the room, which is New York. New York, probably after California, is probably the biggest state in terms of number of lawyers in the union. They're currently considering 2 versions of the rule. 8.4G, and 8.4G Lite. The Lite version is slightly better, but I still think it's problematic. 8.4G itself will be disastrous. That comment period finished this past summer, I think in May or June. So we're waiting to see what they do. If New York adopts 8.4G, they will be sued in so many different ways because there are a lot of lawyers in New York who don't want to deal with this garbage, right? I don't think Ohio, no, okay, my good friend Lee is shaking his head no. I don't think Ohio is going down this path, which is, I think, fortunate. I don't know about Michigan either. I don't think they have right across the border. But these sort of movements will eventually come your way. So I'm talking here not to a group of law students. Actually, there's some law students here, but I'm talking mostly to practicing attorneys. And I want to sort of speak about this at a different level, right? Why is there a push for this law, right? Why are they pushing for this law? So I'll give the simple answer first, right? One of the primary drivers of this law was fears of sexual harassment. There are a lot of people who testified before the committee, specifically female attorneys, and they argue that they're subject to harassment. And not just harassment in court, but also harassment outside of court. So for example, during a deposition, or during a limousine ride to a hearing, or at a bar after some proceeding, or at a state bar function. There was testimony that attorneys would ask an associate to come back up to the room after a hearing, that there was inappropriate touching and things of that nature in car rides over. So there was definitely a concern that the bar wanted to regulate and prohibit this inappropriate touching. And I think that's why they crafted the rules broadly as they did, to apply to conduct related to the practice of law. Right? They didn't want to just say legal practice, because you get around that pretty quick. They want to have an all-encompassing rule. My response to that, I think, is a couple-fold. One, I don't know that the state bars have that much power, right? They're just an entity created by the state courts for a limited purpose of regulating the legal profession. I don't think they can concern themselves with every facet of a person's existence. I actually think that's a bridge too far. In fact, as a matter of state constitutional law, they may be going beyond their authority, ultra vires claim. I don't think they even go that far. But that's why the ABA created such a broad-scoped rule. Okay? But let's talk about this on a different level. When you start to regulate conduct related to the practice of law, you have to recognize what are some things people do in social functions. Well, as Federal Society members, as I think most of you are, we go to debates. We go to lectures. And at these lectures, often things are said that are not in the PC mainstream, right? Poor Lee almost got canceled by his college, right? I've said far worse. I've done debates on affirmative action, same-sex marriage, abortion, gay rights, Second Amendment, whatever topic you want. I've talked about it. I'm sort of traveling hired gun, I suppose. Any one of those talks could have given rise to liability under 8.4G. I reasonably know that some student somewhere will take offense at my speech on one of those 11 prescribed bases. I only have 11 fingers, right? On one of those 11 prescribed bases, someone somewhere will have taken umbrage. And if I go ahead and give that talk on the due process rights of students in sexual harassment Title IX proceedings, right? If I even suggest that a right of cross-examination is warranted, I will likely cause offense or demeaning conduct on the basis of gender or gender identity or sexual orientation or any of those other buckets. right? So I don't think the ABA intended this rule as a tool of censorship. Some people probably see that as a plus, as a feature, not a bug. But I don't think that was the intent behind the rule. But that intent should be obvious now, right? If after people like me complaining for 4 years about this rule and you're still pushing it, you have perhaps one of two explanations. One, yeah, that's the point, right? We want to shut down Blackman, right? And if that's your goal, bless you, I appreciate your honesty, but you've just admitted you're violating the First Amendment. But there's another defense that I've heard commonly, which is, well, yeah, at the margins there might be some cases where this rule is abused, but so what? People can raise an as-applied challenge and you can dismiss bad prosecutions. Whoa, right? We're not just talking about sort of social sanction. If I am subject to a disciplinary proceeding, I can lose my law license, my livelihood. This is my job, right? If I get disbarred, I think I'm going to be fired. Maybe not, but you guys will be fired, right? If any of you got suspended from the bar for 6 months, you probably lose your jobs, right? If any of you had a disciplinary letter from the bar on your record, you probably lose your jobs. You have to disclose that to your clients, right? Tell your clients, hey, yeah, I got this sanction. I can't represent you for 6 months because I give a speech on same-sex marriage. Sorry. Right? Once you realize that someone's life, liberty, and property are at stake with this sort of approach, the bar's benevolent intentions sort of fade. Now, you would think that after all these years of me complaining, they would say, okay, you know what, Josh, we see your point. Let's try to draft the rule more narrowly, right? Let's try to frame the rule so we're not shutting down conduct in debates. We're only actually going after real sexual harassment, like actual bad stuff. So, for example, I proposed adding a severe pervasive requirement, right? That if you engage in conduct that's severe pervasive, this is the language used from Title VII context, then you might give rise to liability. But a single debate speech is not going to be enough. But they worry. They say, no, we can't do severe pervasive. That will let too many bad guys go free, right? They want this rule to be broad and sweeping. And by making it so broad and sweeping, they are going to chill debate. Now, so far, again, only a handful of states have adopted it. I'm not aware if any New Hampshire lawyers have been subject to discipline. I don't think so. But it's coming, right? Currently, the judiciary, most attorneys grew up in an age where free speech mattered. I think at some point, that sort of culture starts fading. And the law students of today who don't value free speech as much will become the lawyers of tomorrow. And then those students become judges. And those students become state bar presidents. And those students will sit on various committees approving these sort of rules. So I think we're fighting something of a losing battle, right? I can be up here in the year 2021 making these points, but in 10 years from now, I don't know that they'll have the same culture against censorship that exists today. And ultimately why this is important, and this is why I'm so glad my friend Lee is here, is we need contrary voices in our profession. People who don't say the same things. If everyone says the same things, people have to sort of sit and sulk in the closet. They're just, they whisper in the shadows. We need people to be able to speak openly and publicly. Even if my approach perhaps allows some harassment to go on, right? Even if having this sort of open-ended standard allows some misconduct, that might be a necessary cost, right? Trying to shut down every possible act of misconduct risks sweeping in good conduct that you prefer. And this is a classic, 1L debate about criminal law. The more you enforce the law, the more likely you are to punish positive conduct. But fortunately, I think the bar is an easier task. Do your damn job, right? Regulate the practice of law. Focus on the things in your area of expertise, legal practice, court skills, honesty, transparency, managing client relations, not cheating from your clients, right? There are lots of things for the bar to do. This is not one of them, right? The bar is not this sort of super entity that ensures that at all facets of an attorney's career he's behaving, according to the dictates of Ibram Kendi, right? This is not the bar's job, right? They should focus on their own world. But I see 8.4G sort of a canary in the coal mine. right? I want to read a bit from the judge in Philadelphia's ruling. And I think the judge summed up quite well my sentiments. He says, "There is no doubt that the government is acting with beneficent intentions." I agree. However, in doing so, the government has created a rule that promotes a government-favored viewpoint monologue and creates a pathway for its hand-picked arbiters to determine, without any concrete standards, who and what offends. This leaves the door wide open for them to determine what is bias and prejudice based on whether the viewpoint expressed is socially and politically acceptable and within the bounds of permissible cultural parlance. Yet, the government cannot set its standards by legislating diplomatic speech because although it embarks upon a friendly, favorable tide, this tide sweeps up all along with the admonished minority viewpoints into the massive currents of suppression and repression. Strong words. Our limited constitutional government was designed to protect the individual's right to speak freely, including those individuals expressing words or ideas we abhor. There was a time when we often said, "I do not agree with you, but I'll defend your right to say that." Right? There's a missive forever, from flag burning to other missives. I fear that culture has sort of faded, that if it's an idea we abhor, the answer is to simply silence it. It's truly, if I may just take a step back, it's truly a form of power control, right? To tell someone that you can't say something to exercise control over their mind. I don't want to sound conspiratorial, this is not my intent, but if I know that there's something I cannot say, that idea is simply removed from my mind. I have to keep it inside internally. And one of the reasons why historically we allowed abhorrent ideas to be uttered was to prevent that sort of control. But I think today far too many people want to exercise that control. Students, and now the bar. Okay, so I've given you just the broad philosophical arguments about why this rule I think is a terrible idea. It's also unconstitutional, right? There are all these very good policy arguments, but there's a constitution, right? There's actually a First Amendment case law. Right? So, first off, the First Amendment asks about chilling effects. This law absolutely has a chilling effect on free speech. If I know that my lecture on some topic might give rise to liability, I simply will not give the lecture. In that regard, the law has what we call an ad terrorem effect. It inhibits you from giving the speech that could be punished. I think it's a very significant effect. I will simply not do it. Okay? Second, I think the sweep to the bar associations, the social functions, goes too far. Constitutional law, for better or worse, is kind of a balancing test, right? You assess the means and the ends, right? And how close is the fit between what you're doing and what you're trying to achieve? The bar's power concern legal matters. As the bar kind of moves away from that core competency, the fit between the means and the ends becomes less tight. And with First Amendment scrutiny, you need a very close fit between what you're trying to do and what you're trying to achieve. The bar doesn't have as good of a reason why they're regulating private conduct in social activities. Merely saying it's connected to the practice of law is not going to be enough, right? Unless there's some showing that the conduct affects a lawyer's fitness to practice or the administration of justice, I think they're out of line, right? There are three general heads of what I think a lawyer actually does. These are the three heads, right? Conduct during the practice of law, representing a client. Conduct that reflects a lawyer's fitness to practice. And conduct reflecting the administration of justice. Those are the three broad heads. I'm okay with those, but the social activities goes too far. There's also a form of viewpoint discrimination in the rule. And this one's actually kind of sneaky. So the rule says you cannot engage in demeaning speech based on race. Okay, so imagine you're SOB, conservative lawyer, you're a bit of a jerk, right? You're a troublemaker. And you find out that your firm has a diversity inclusion policy. You say, aha, I find that offensive based on race because you're using racial quotas on your hiring policy. And you have a bunch of conservative lawyers filing complaints against diversity inclusion policies. Come on, you know they would, right? You can't. 8.4G, I'm not making this up, says, lawyers may engage in conduct to promote diversity without violating this rule. It says this: if you favor diversity and inclusion, you're insulated from liability. If you oppose those measures, you're on the hook. So the rule on its own terms creates a carve-out for a certain type of speech. This is doubly damning. First off, it's viewpoint discrimination, right? You can't favor one side of a debate. But it's actually even worse. This carve-out gives away the game. The people who wrote this rule knew that it can be used to shut down debate and discussion. But they like their debate. They like their position. So they created a loophole where their debate's fine. So I can go up there and say, we need diversity, we need inclusion, we need quotas, all this other stuff. But if I criticize that, no, you can't do that. This gives it away, right? So again, was this a well-intended rule? I think so. But they recognize, based on this carve-out in the comment, how this rule can be abused. So far, again, only a handful of states have adopted it, and there's been a very broad opposition. But I think this is a losing battle. If I come back to Ohio, Toledo in 10 years, see all of you again, your old partners, making big bucks, right? More states will have adopted it, right? I see this as a losing battle, but I can only sort of fight as long as I can. All right, I've been talking for about half an hour. Let me shut up, and I welcome any of your questions. Thank you so much. Yes, go ahead.
The most
go ahead.
concerning thing that I heard from your comments was that you thought the current generation of law students had a diminished respect for First Amendment values. Can you expand on that a little bit? What is that comment based on?
Lee? No, don't say anything. I'll answer the question. It's funny you got up at that moment. Well, I'll give you a personal experience. I was protested a couple years ago to law school. I was invited to give a speech on free speech. The topic was free speech on campus. And about 50 law students were shouting me down and protesting. That's my own personal experience. But other law schools, students have filed complaints and become offended at any sort of effort of professors to challenge orthodoxies on gay marriage, on abortion. There have been efforts to remove professors from the first year of classes. They can't teach. I can give you a list quite long. But the idea of defend the speech, even that we disagree with, I think is sort of waning in recent years.
One data point, Josh, and that's so there's the Foundation for Individual Rights and Education. They do surveys of students every year, and I think it's the lowest statistically reported support for free speech among young Americans. So it's publicly available.
Okay, other questions? Yes, in the back.
Yeah, so before I get into my question, I think this is kind of a unique way of tying in. As an example, we talk about censorship in regards to this ruling on Canada as an example. They are already censoring speech in regards to pronouns because that is actually happening. You hit on a point in your speech about, is it too late? So I think more of a two-part question. One being that in regard to this rule, would our liberal counterparts be in favor of stopping this? And the second part of that question would be, what's the future in case this rule is in effect in Ohio?
Yeah, it's a good question. So you mentioned Canada. I'll start with our friends up north. Actually, is Canada from the north or south here? Because I know it's kind of with Windsor and Detroit, it's kind of this funny thing. But, our friends sort of up north. Canada basically enforces 8.4G, and they enforce it in a sort of even broader way. There was an attempt to open a religious school by Vancouver. Was it called Trinity? Yeah, it's called Trinity University. And like most religious colleges, they require their students to sign a statement of faith. And as a Christian university, it's a pretty basic tenet that there's no sex outside of marriage. That's a pretty basic tenet. And one of those tenets is gay couples cannot get married, so therefore it's impossible for a gay person who has relations with another person to sign this statement. The Canadian law authorities, did they ever get a credit? I don't think they did. They would not accredit the law school with the law authorities. In other words, a person who went there cannot sit for the bar exam. If this sort of policy came to the United States, I think Notre Dame, BYU, other similar schools would have to shut down. They could not offer legal education unless they don't stop enforcing their creeds. So I think that to answer your question, if we look to our friends up north, sort of a preview of what's coming down here. How can you resist this? How can you fight it? You can do what I do. File comments, attend bar meetings, right? Don't let these sort of agencies become captured by the left, right? We're allowed to speak also. We're allowed to go there. So again, I told you, I filed comments, I think, in almost 20-something states. I've lost count. It's the same comment over and over again because it's the same damn rule. But when they have these comment periods, read your bar journals. Don't just throw it in the trash, right? Or the email. Don't just click delete. And flood them with comments. And let them know that they're going to have to deal with public outrage if they go down this path. Become members of the various committees, right? The disciplinary committees, right? Volunteer for this. I think FedSoc should definitely look at having people as bar counsel, right? You know, the actual people who investigate, we should encourage our members to apply for those jobs, right? There's actual misconduct, people stealing client funds, right? There's really bad stuff lawyers do. Don't focus on this stuff, right? Focus on the actual misconduct, right? People committing perjury, people filing frivolous lawsuits in court after court. I won't mention the election litigation, but there's a lot of really bad stuff. Sorry, too soon. There's a crack in here? No, right? There's misconduct. I think this is the last thing from the court's mind that we were focusing on. But did I answer your question a little bit? Okay, thank you so much. Okay. Yes, Lee.
One of the allegations I heard against the proposed rule is that being a member of a religious organization that have all the wrong views, that by itself would be a reason. And I take you to say, Josh, is today that not unless it's a social activity related to the practice of law. So maybe St. Thomas More Law Society, being a member of that, which would have the wrong views, would that be violation of 8.4G? So it's a group of religious lawyers, and they've got the wrong view on, pick your subject, and they do social events.
I think so, right? Right. So if you couldn't hear the question, a group of religious lawyers who engage in a social event. So let's say the Thomas More Legal Center hosts an event on abortion, or same-sex marriage, or transgender bathroom, whatever the issue is. If someone walks in that room and they find that a speech is perhaps demeaning to them because of their sexual identity or their gender identity or sexual, I think they could file a complaint. I think that complaint would be probably tossed on First Amendment grounds, but even having a complaint filed against you might be too much of a chilling effect, right? Again, if you had a complaint filed against you, I think you have to tell your boss, your partner, right? If you don't tell them, you're screwed. And your partner may say, what? What did you do? And he may say, you got to apologize, you have to withdraw from that organization, you have to resign, make this go away, I don't want this hanging over my firm as a cloud over my firm. So even if the rule can't be constitutionally enforced with respect to these religious attorneys in the group that Lee mentioned, it could be used to simply shut them up. Now again, I am a tenured law professor. Most of you aren't, right? They can't fire me, right? Within bounds, but it's very hard to fire me. Law firm associates are like a dime a dozen. They can toss you in 2 seconds. So that's why I think this rule is so pernicious and why it has to be opposed on its own terms. That's a good question, Lee. Other questions you guys have? Yes?
What would your response be to, like, when you were at the law school in New York and they tried to cancel you, heckle you? What would be your response to the fact that they were just engaging in more speech and that they weren't actually trying to shut you down, and that if we go too hard against the cancel culture, we're just shutting down speech we don't like?
Yeah, it's a good question. So for those of you who don't know, in 2018, so about 3 years ago, I gave a speech at the CUNY Law School in New York. And the topic was Ironically enough, free speech on campus, right? That was the topic. They organized a massive protest. There were nearly 50 people. And as I was walking down the hallway to the classroom, they were shouting at me, and they were screaming at me, and they were calling me a fascist and a Nazi and a white supremacist, and every word in the book. You've heard them all. I'll be honest, I wasn't troubled by that part, right? I think it's entirely appropriate to stand outside of a classroom and make a person feel uncomfortable, right? They were using their words to counter my words. I was going to their school, and they were shouting at me. I'm fine with that, right? You know what? If you want to hold up a sign and call me a Nazi, God bless you, right? Good for you. One kid, he actually tried to block my entry to the room. He sort of put his backpack in front of the door. That's a different story. Blocking physical access is something. But I kind of said, excuse me. I sort of gave him a little stiff arm. And he was out of the way. He didn't put up a fight. I didn't do anything. Okay. Then I get to the classroom, and that's when things get a little bit messy. There were about a dozen people standing right behind me. So where this chair is, imagine 12 people lining up right behind me. They were standing maybe a few inches even, behind my shoulders. And they're holding up signs. And they were shouting and screaming. Whenever I opened my mouth, they would scream and shout. That is different, right? I draw a distinction between demonstrating and disrupting. You can demonstrate, you can't disrupt, right? When you're shouting over me, I can't speak. One person speaks at a time. That's a very simple rule. You can't have two people speaking at the same time. And to make the point even more concrete, when you're standing over my shoulders, that creates apprehension, because at any moment it can get violent, right? Remember in torts, the reasonable apprehension, imminent bodily harm. Remember that standard? If you're standing 6 inches over my shoulder, I can't see you. My back is to you. If one of those kids took their signs and knocked me over the head with it, right? I had no security. There was a plainclothes cop guy in the back of the room. He couldn't protect me. In fact, the security guy asked me before the event, he said, I'll never forget, he said, what's your exit strategy? My what? What's this, Iraq? What's your exit strategy? In other words, how am I leaving the building? I said, I don't know, I'll take an Uber. He's like, okay, good, you're not taking the subway. I'm like, oh. Here's where they followed me to the subway. This was in New York. So again, I draw a divide between disruption and demonstration. Demonstrate all you want. Make me feel uncomfortable, but don't disrupt me. Excuse me. What other questions you guys have? Yes, go ahead. Oh, that was an elbow. What other questions you have? Yes, go ahead.
The last speaker that Carl brought, 4 or 6 weeks ago, was on the topic of